Hail there, legal warriors. In this video, I'm going to cover something I'm not very happy about. More and more people are getting restraining orders against minor children. If that happens to you, if you're thinking about getting a restraining order against minor children, I'm going to cover what happens, how this can affect school, and what anybody can do about it. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get to see it. More people will get the help they need. I'm just going to jump right into it. I said the word restraining order because that's what most people in the public call it, and I'm in Washington State. Literally, they're called protection orders, and there's several videos on this channel about protection orders, but a protection order is not a criminal matter. It's a matter where one person says, I want an order against somebody else that restricts their rights. And if they violate that order, then it is a crime and they get arrested. And most commonly you see that, neighbor on neighbor, partner on partner, domestic violence, anti-harassment orders. But what's been coming into my office lately is a whole ton of order cases involving minor children, like at a school or something. And that can have a real big effect. And so if we want to talk about what happens, we want to cover probably three things. What to do if you get served with the order and you're on the respondent side, how that's going to affect your kid, right? Will they still be able to go to school? And what we want to do to fight about it. And finally, the third thing, what if you're the one looking for an order against the minor child on the other side? Is that a good idea? So let's say you get the knock on the door. What do we do if we get served with this thing? Well, we want to read it, right? You're going to be served by a police officer typically with a petition, which is the reasons why the person who wants the order, their petitioner, is asking to restrain the young person, and also a temporary order. And we have to read that temporary order. What do we want to look at that? We want to look at what the return date is, what date it is that you have a chance to go back to court to say, hey, they shouldn't have this order. And also, if there is a restriction, what are the restrictions? Is your own child restricted from their own school? And the answer is probably yes. If your kid goes back to school, they might be violating the law. And under the way it's working now in Washington, they might get arrested, which I don't think makes a lot of sense. They may not be able to certainly contact the other party, so you need to read it and make sure that you know what it says so there's no accidental violations. So then we have to take it seriously. Now, that's probably not a problem. Most parents, when something is going against their child, they're going to take it very seriously. It's going to be very personal. It's going to be very upsetting. But we have to take it seriously, and we probably should get a hold of an attorney so we can respond to the order. And if you haven't been watching this channel for long, you may not know how orders are responded to in Washington State. You don't just go into court and testify about what happened, because the court doesn't have a lot of time to deal with these. The statute, RCW 7.105, is a terrible statute. I curse the legislature myself for writing the statutes. It's a disaster. It creates a lot of business. It creates a lot of pain. It's just really, really aggressively used, and it causes all types of problems, including minors getting orders against minors for kid stuff, typically that in the past would just have been dealt with the parents or dealt with the school. But we don't just go in and testify. We need to file a written response, an affidavit about what our version of events is, right? Hey, maybe our kid did not push this other kid. And even if our kid did push the other kid, it may not rise to an order. Certain types of orders require substantial emotional distress and a pattern of conduct, not a one-off. But unless we file a written response, when we get to the hearing, the court has already read all the petitioner's stuff. They may only have 5 minutes to deal with it. You need to have your written response filed ahead of time. And we want to be careful how we write those responses. That's why you need attorney help oftentimes. We need to write the response consistent with opposing what is statutorily required on the other side. Unless there's a dating relationship, almost always student on student or kid on kid type stuff is going to be an anti-harassment order, where the respondent needs to have engaged in a course of conduct directed at a certain person, the petitioner, designed to cause them severe emotional distress, and there has to be no legitimate purpose. So I've seen a case come in recently that had video with one kid shoving the other kid, but on the video, the kid who got shoved, the petitioner, they were smiling. They're just, oh, no big deal. Yet apparently, who files these? Well, the parent got involved and filed the action against the other person. So in that case, if I was working on a case like that, I'd probably be making the argument that there's no severe emotional distress, the kid's laughing about it, right on the video. But if you don't have attorney help, you may not even be able to introduce that evidence correctly into the court file. We have to take it seriously because we only get one shot at these things. So what happens is we show up at the hearing, they've read the response, hopefully the court has, the petitioner will get a chance to say some things, the respondent will get a chance to say some things, and then the judge will make a decision. And what might they decide? They might decide to grant the order, they might decide to not grant the order, and if they do grant the order, we're going to want to talk to them, hey, we still want to be able to go to our school, and the court doesn't have to allow that. Many times people have to change schools if they get this order granted against them. So what's another possible solution? What solutions have I seen? Well, if you have an attorney helping you, you may be able to get a CR2A agreement. That's a civil agreement outside of the court process, the judge deciding between the two parties. In other words, we might be able to work out something short of an order where, hey, my kid leaves your kid alone, and we don't have an order that prohibits us from going to school. I've seen that happen as well. So what's the big point for the respondent? We're the ones getting served. Well, one parent on behalf of the kid is serving you, another parent on behalf of your kid, and we've got to go to court, we've got to read it, we've got to deal with it. Now, what if you're on the petitioner side, you're upset about something that's happened to your kid? Well, it's probably pretty easy to get an order, right? Because these things are routinely granted. But you want to think about, is that what you're really trying to accomplish? Is if your kid's being bullied at school, it's probably not just one kid doing it, right? You need to possibly, more likely, try to deal with the school first, because these protection orders are not designed to deal with these one-off things in a school situation. The court doesn't like it. The court doesn't want to do it if it doesn't have to, and it's certainly not their job to monitor all of that. It also causes a lot of stress and destruction to take something to court, right? It can enhance the problems in the future. So you should think about, if you have this type of situation, you think you want an order for your kid, and maybe you do need one. I'm not saying you don't, but if it's just a school-based thing, then I would suggest you exhaust the school issues first, then contact an attorney, hopefully someone who locally works in the area, about, hey, is a protection order, a restraining order, a good option for what I'm trying to accomplish, or am I just mad and I don't know what else to do, and this is something that I can do, so I'm going to do it because I'm so mad. And it makes sense. We're protecting our own children, but we're looking hopefully for a long-term solution, not a short-term solution, because these orders are not going to last very long. So this is a really, I think, unexpected use of this statute by the legislature. I would hope we'll see some amendments in the future, that we don't have 8-year-olds and 7-year-olds suing each other in court for protection orders. I'm disgusted by it personally. But if you have this type of situation, you can always reach out to my firm. I'm in Washington State. If we get on board, we can listen to what happened, we can identify a way forward, and we will be there for you. Thank you.